Welcome to this webinar in which we're going to discuss the use of mediation to help resolve disputes encountered by building surveyors in their day-to-day practice. I'm Simon Williams. I'm a barrister specialising in property work, but perhaps more pertinently for today's purposes, I'm also a mediator. I've been mediating for about 15 years now. I'm joined by Ben Devonport of HartDixon, a chartered building surveyor, who's going to describe to us a number of situations he faces in his day-to-day practice. And then I'm going to explain how, in relation to each one, we might use mediation to try to sort them out. First, Ben, before we get into the scenarios, it'd be interesting to know how you currently approach this type of situation. That's to say, where you're working on a project and you sense that a dispute is coming about. So how do you deal with that currently? And at what stage, if you do, might you start thinking about the use of some form of alternative dispute resolution?
Yeah, thanks, Simon. Just to follow on from what Simon was saying, I'm a building surveyor. I specialise in commercial property, so acquisition reports, dilapidations, project management, and then there's another array of services we offer to do with reinstatement, insurance costs and things like that. But I also work residentially too, and mostly on the residential side it will be to do with dispute resolution. But I think from answering Simon's question really, we don't often know whether we will be entering into a project or a matter or instruction, and we don't often know whether that will lead to a dispute. I think what we do try and focus on is the first thing we try and understand is managing the client and their expectations, understand their brief and all the stakeholders that are involved. And then on the first instances, we'll try and, it's part of our job really to understand and negotiate and fulfill the client's needs so that we can try and avoid any disputes if possible. But having said that, being a building surveyor, we are legislated by the RICS, I'm bound by the RICS, and we have to brief ourselves and make ourselves aware of their guidance notes. So we broadly, as building surveyors, we understand the three main pillars of dispute resolution. The first one being negotiation, then mediation, and then adjudication. So like I was saying, my sort of main involvement will be through the negotiation ways. In some contracts there will be some arbitration or adjudication matters that are bound by the contract, but I think there are many situations which I come across where mediation could be hopefully a sort of shortcut to resolving those disputes and perhaps save both parties costs and time. So I think from my end, Simon, it'd be really good to understand, how mediation works if we were looking to appoint someone like you or, someone in that realm, and sort of, just a brief explanation on, where would we go, what parties would we need, things like that.
Sure. Well, just very simply, as I'm sure many people are aware, mediation is it's a simple process. And quite simply, a neutral third party, the mediator, assists the parties to reach an agreed solution to their dispute. We do that by talking them through it individually, first of all. Sometimes we get the parties together to discuss things around the table, but just obviously depends on the nature of the dispute and whether that's advisable or not. And then we spend the time passing messages from one side to the other, or helping them to communicate through us, with a view to ultimately bringing them to a point where they find a mutually agreeable solution to their problem. That lasts generally no more than a day. Sometimes it spills over into more than one day, but usually a resolution can be reached during the course of one day. And that really is the essence of it. It's a very simple process, as I say, and to my mind, there are 6 principal points which are worth bearing in mind and give it a distinct advantage over other forms of dispute resolution, particularly litigation, of course. And they are primarily cost, because certainly if I were to mediate a dispute of the kind that you're talking about, Ben, early on in the process, the chances are that the only additional cost would be the modest fee of the mediator for the day. Then the other important aspect of it is confidentiality. So you can have the mediation without anybody else knowing about it, and hopefully nip the issue in the bud without it becoming publicly known. Speed can be arranged very quickly, almost overnight. If a mediator is contacted, assuming they're free within the next day or two, they can attend a mediation. They need little in the way of pre-information, just an outline of what the issues are, possibly some of the important documents, but often that can be explained on the day. It's an incredibly flexible process. The parties can arrive at any solution they think of. They're not bound, rather like in court proceedings, there are certain remedies that the judge can grant, but in mediation, anything that the parties can come up with, they can incorporate into their agreement. And agreement is the essence of it. It's an outcome that's agreed between the parties. It's not something that's imposed on them like a court judgment. And the attraction of that is that if they've agreed it themselves, there's much less chance of it unraveling. There's no need for enforcement, or less need for enforcement, because again, if they've arrived at it consensually, then hopefully it's something that they're broadly content with. And then overall, the overall overriding factor is control. It's a voluntary process. So the parties determine if, when and how they're going to mediate, who the mediator is going to be. They appoint him or her themselves, and are in complete control of the situation. Unlike, as I say, something like litigation, where it obviously often gets completely out of control and spirals into lengthy and costly proceedings. So that's hopefully that's given you some idea of what it's all about. Then let's, with those preliminary thoughts in mind, Ben, let's turn to your case studies, and you run through each one for me, and then I'll give you an idea of what mediation can do to try to resolve the issue that you've encountered.
Yeah, thanks very much. Yeah, I'll try and keep this as non-specific as possible. I don't want to upset anyone who potentially related to these. Yeah,
we won't mention any names.
No names. But for instance, this is one that I've been sort of thrust into recently. I was appointed by a landlord to help them undertake some project management and contract administration works. This involved them leasing a unit to an existing tenant, and the deal was around, if they took the lease on, they had to appoint me and a contractor. But the landlord had already privately negotiated with the contractor and agreed a cost, and then they had appointed me to then oversee that on behalf of the tenant. So it was a bit of a chicken and egg scenario, because the tenant wouldn't take on the lease unless the works were agreed, and the works were only agreed if the lease was going to be taken on. So it was both things had to happen. So we got very far with this process. I'd just been taken on, everything seemed very straightforward, and then the contractor at the last minute turns around and said, we're not happy to work or be appointed by the tenant through various compliance reasons, and therefore the whole deal was about to fall down. I think the problem, or the issue that I'd entered there, is that, having spent a lot of time and work, could mediation have been implemented before I'd even engaged? Or, I think, what we wouldn't want to happen is both parties to walk away without this deal going through and a lot of professional fees being spent.
Sure. Well, look, I mean, as I said earlier, you can mediate at any stage. So you can bring in a mediator at any time you sense that there is some issue. And the attraction of doing that is that people raise objections to doing things, as in this case, the contractor refused to enter into the contract for whatever reason. I mean, there was possibly a reason stated, something to do with credit or whatever, but that's not always the real reason. The bottom line is that disputes arise often because of personality issues. Somebody doesn't like somebody else, they don't feel they can work with them or something. They dress up the dispute on some pretext, whether it's legal, contractual, or whatever. But the underlying issue is what you need to get at, and that's where a mediator can help, because they won't want to, the other side, the contractor or whoever it is, won't want to talk to you possibly about what the problem is, but they might be prepared to talk to a neutral third party. And the work of the mediator, first of all, when he or she becomes involved, is to work out what it is that's what's really driving the dispute. And once you can find that cause, that underlying driving factor, then there's a good chance that you'll be able to lead the parties to a mutual arrangement whereby they can take things forward. So the first thing to say about mediation then, and this demonstrates, is that it's good to talk. And if you do, it helps also the parties to get things off their chest. If there's some issue that that's really annoying them, sometimes just talking to somebody and letting them get it off their chest, what mediators refer to as venting, is the first part of the process, and it's very valuable. It's cathartic for the parties, and what that does then is get the parties to a point where hopefully they can start thinking forward positively and constructively and come up with a solution which will enable them to make it work. And that's obviously crucial when you're in the middle of a project and everybody just wants to get on with it and get the deal done. So that's what mediation I think could help with in that situation.
Yeah, no, you're totally right. I think just a thought on that one, you don't often see mediation clauses in JCT contracts. I don't know whether you had any thoughts on that. Usually it's straight to arbitration or adjudication.
Yes. Well, they vary. I mean, you may well be right. In JCT contracts, that's often the case, but it doesn't mean that you can't mediate. I mean, that's the contractual dispute resolution clause. But it's the same in litigation. I mean, that you can mediate at any time, even while litigation's going on, arbitration or whatever it is. There's no reason why the parties can't, as I say, quickly set up a mediation, bring in a mediator and see if they can resolve the dispute. And then obviously if they can't, they can always go back to their original dispute resolution process.
Right. Thank you. Yeah, so moving on to the sort of second scenario. So on this scenario, I'd acted for a landlord in a dilapidations claim. So after the lease expired, the tenant moved out and the landlord undertook the works. There was a unusual clause to do with the rent deposit, and because an agreement couldn't be reached with the tenant, the landlord decided to release the deposit less the residual claim. So a small portion of rent was released back to the tenant. The tenant is still fighting the claim, yet the landlord has carried out the works, proved the loss, served everything they should have served under the solicitors. And now we're months and months later and both parties are left with an unresolved issue. So not sure how to proceed forward.
Well, the thing about dilapidations cases is that the parties usually have a pretty good idea before the end of the lease that, that there's going to be an issue, and ideally that is the best time to mediate, so that they've still got a number of options open to them. But you can mediate any time, as I've said, and no reason why you couldn't do so in this case. Obviously desirable, because although you've reached a certain sort of conclusion, there's still plainly the threat of proceedings in the background, and as things stand, that may be the only other way to resolve it. So, those proceedings are going to be time-consuming and costly. So, definitely worth trying mediation. A one-day mediation, modest expenditure, likely to help the parties sort things out and then be able to move on.
Mm. Yeah, no, I think that would be a wise way forward in that situation. I think, yeah, we're obviously reaching a point where both parties are quite tired of the matter, and I think mediation would be a good way to try and end it on sort of friendly terms.
Well, I mean, that is the other important thing to bear in mind, Ben, is that you can be sure if you end up in court, then the parties are never going to speak to each other again, and they're certainly not going to do business again. I mean, I know in this case, obviously, the tenant's leaving and may not want to be back in those premises, but I mean, there's always the potential for future business relations between parties. And the great thing about mediation, again, is that you can resolve disputes in a way which it gives you a reasonable chance of being able to do business again.
Yeah, yeah, absolutely. So on to the third situation, which was more of a residential dispute, which I've recently been involved with. So the landlord was notified of some disrepair by a tenant, and they had actually received a court order to undertake the works. So the landlord did the works. However, there was some complications because the tenant was a local authority tenant, AST tenant, and they appointed their experts to contest that the works were actually completed properly. But the damage is so minor in comparison to the amount of professional fees that are being racked up, the dispute itself. And my involvement was just to prepare a defects report, just to get some sense on what the tenant was saying. But all parties are looking at incurring very large fees, and it's a minor issue. So I think, what would your advice be in a situation like that?
Yeah, well, I mean, this is the classic situation where you've got cost of repairs, possibly even less than £10,000. I don't know how much it is in this case, but legal fees and other, legal and professional fees, could be 20 to 50,000 per party or more if you end up in court. And of course, if the claim is for less than £10,000, there's a possibility it could end up in the small claims court, where unless you can establish unreasonable behaviour by the other side, you're not even going to recover your costs, even if you're successful. So absolutely paradigm situation to bring in a mediator and try and resolve this in a manageable and cost-effective way. Where you've got a disrepair situation, often worthwhile holding the mediation on site, so that the mediator, you can walk around the site, each party can identify the issues and discuss them, possibly even together in front of the mediator, and certainly go back and refer to them on and off throughout the day. And you'll probably have a Scott schedule in your hand as you walk round. You can look at each issue item by item on the Scott schedule, work them through one by one, and try and come up with a workable solution. And again, having the mediator there, almost sometimes physically keeping the parties apart, obviously enables that sort of conversation to happen. Whereas, one knows from experience that even sometimes when experts meet on site, things can get out of hand. But having literally somebody there to sort of stand between the parties, it's surprising how much more of a conversation can be had and progress can be made to get resolution on an item by item basis. And as I say, in a claim where the costs are going to considerably outweigh the amount in dispute, that's obviously an advantage for everybody concerned.
Yeah, I often feel, I suspect most of the people viewing this webinar are mostly from the commercial sector, but with residential property, it tends to be very emotional, and I think things at a risk of spiraling out of control, they aren't often advised very well, and I think mediation is a very good thing to sort of recommend early on, because the costs are just, like you say, just vastly outweigh the problem, which is usually born from an emotional, type of situation.
Yeah, but even on in a commercial context, Ben, I mean, similar things arise, and what I was saying earlier about personalities is equally an issue. So the numbers may be a lot larger, and there are other attendant issues. But ultimately, as one's experience tells one, that these things do often come down to the personalities. And again, if you can get on site with a mediator, sort of keeping the personalities, I hesitate to say under control, but certainly calmer, then again, you can make significant progress, and that's one of the attractions, whether it's a small scale residential case like this, or indeed a larger scale commercial disrepair type situation.
Absolutely. So yeah, moving on to the sort of another scenario. This is a very common one that we encounter as building surveyors. I think as times move forward and construction is modernised over the years, there's an encouragement these days for team working and working together, and that sometimes can evolve into a sort of a mesh of people just requesting things all the time without the processes being put in. So in this scenario, this is a construction project. The client will, in this scenario, cuts out the project manager and contract administrator, who essentially is in charge of directing the work. And they have gone behind their back and they've asked for additional works and costs from the contractor. The contractor happily supplies that, and they do the work. And it comes to the final account, and the contractor said, well, actually that work took me another week, and I'd like another load of preliminaries because that wasn't explained properly or gone through the proper channels. Yeah. We've now fallen into dispute because the client wasn't aware, so they're unhappy with the contractor. The contract administrator isn't happy because they were cut out, and the contractor wants some more money for doing more work. So very common dispute that we see.
Yeah, sure. Well, again, as you say, another classic situation. So in the heat of the project, there's been either a breakdown of communication, or, as you say, procedures haven't been followed, possibly quite legitimately with a view to keep speeding things up and getting things done quickly. But of course, then there's always the risk that something's overlooked or there's misunderstanding, and that's how these disputes arise. So again, rather similar to one of the scenarios you described earlier, what it needs is an understanding of obviously, first of all, where it's gone wrong, but also there's often some ill feeling on one side, and finding out exactly what's driving that. It may be the problem, but again, that might be being used as a pretext just to manufacture a dispute, or it's caused some ill feeling. So again, bringing a mediator in, talking to the parties, working out exactly what the problem is, and in a calm, safe environment. But mediators talk about safe environment. That's what that means, is sort of taking people away from the problem area, which is the site or whatever it is. I mean, sometimes, as I say, it's helpful to do this on site, but equally, it might be advantageous to do it away from site, where people aren't, in close contact with their day-to-day colleagues, and the individuals can reflect calmly and quietly in a different environment with a neutral third party, which again sometimes helps unlock the impasse, the problem, whatever it is that's driving the dispute. So it's a classic situation, and again, talking it through is undoubtedly going to help to free up the problem and find a resolution.
So yeah, I've got a question for you actually on that. So obviously recently we've been going through this period of coronavirus and lockdown and things. How have you managed to sort of implement safe environments without being able to meet up and, you know, go to sites and things like that?
Yeah, well, I mean, as we're doing now, Ben, I mean, this is the way we've been doing it. You know, so many mediators will tell you, I think that they've had to learn very quickly how to mediate online. And that's what we've been doing. I did one last week. And the answer is that with this wonderful Zoom platform with its breakout rooms and so forth, you can do that. You can have a virtual mediation in almost all the respects that you have one face-to-face. There are obviously one or two aspects which aren't quite the same, but it works, and it's produced, it's managed, enabled people to continue negotiating, mediating, resolving disputes throughout the lockdown. And I mean, I think what many mediators have found is that now that they've become conversant with it, they'll be continuing to use it, you know, more and more probably in their practice. So when somebody proposes a mediation, rather than the first question being, well, which hotel or which conference centre are we going to have the mediation in? It'll be, right, well, are we going to do it online? And that'll be the first thing. But the answer is, yeah, we've managed to continue, and we will continue so long as we're unable to meet face to face.
Super. Great. So this is a bit of a different scenario, maybe a bit more personal against me, perhaps. So a while ago, I was acting on behalf of a landlord in a dilapidations case. The tenant left the property in disrepair with all their equipment in there that shouldn't have been there. So we entered into negotiations after the tenant vacated, and well, the surveyor that I was up against, I was slightly younger than I am now, so I was in my 20s, was towards the end of his career. He was an FRICS surveyor, and he wasn't happy that there was any claim whatsoever, and he threatened to have me struck off by the RICS. We did actually eventually reach a conclusion, which I think went maybe towards my side, which was good, but it was a very bitter dispute throughout the process and not an enjoyable one, although the result was satisfactory in the end.
Sure. Well, I mean, another very important issue, particularly for you, you know, your own professional position. The last thing you need is the worry and the time involved in regulatory or disciplinary proceedings, with all the attendant adverse publicity potentially that might bring, and obviously the time and the cost that will be needed to deal with it. So, I mean, as I've pointed out, the first thing to note of assistance is that mediation is entirely confidential. So you can set up a mediation, or you can suggest it, and hopefully it'll be set up in total confidence. So no one needs to know what's going on. It's quick, and you know, in terms of cost, obviously modest expenditure, and there's a good chance you'll be able to nip this in the bud. That's you know, what it can do for you. It's not only useful in dealing with your clients and their problems, but obviously very useful if you unfortunately find yourself in this sort of situation.
Yeah, I think that's good to know from I mean, outside of talking through issues between, you know, parties like clients and contractors and landlords and tenants, I think it's very, very important to know that there's another way that mediation can be used if there are disputes between professionals. And I think, you know, it's of benefit, I think, for surveyors to know that, whether it's a valuation dispute or a service charge or anything else. So it's good to know that that's you know, available, really.
Sure. Yeah.
Yeah, so great. So on to another scenario. This is fairly recent. So I was acting on behalf of a tenant on a dilapidations case. My client was attempting to determine their lease via the break clause. but there was a material compliance break obligation, which we know are very difficult and notoriously difficult to achieve. 6-10 months before the lease was coming up to the break date, we had no engagement from the landlord whatsoever. So we had to navigate completing the works ourselves and make sure they were done correctly before the break date, with all the rents and handing the keys back and possession, everything like that was being done, although it was never confirmed how we're supposed to do that. So we've done all that. And then the break date came, the landlord didn't concede even accepting the keys. It's months later and the landlord still won't engage with us. And we are left with the uncertainty that, maybe we haven't broken or we have broken.
Sure. Yeah, well, again, another classic situation. What do you do when another party won't engage? And obviously one possibility is to do what you did here and carry on as you believe is right. But as you say, the problem's not gone away. A letter of claim could materialise at any time, and you've got the worry in the back of your mind. So suggesting a mediation at an early stage can do a number of things for you. First of all, hopefully the other side will agree, and you have a mediation, and statistically, as we know, there's a very good chance that you'll reach a mutually agreeable outcome on the day, or possibly very soon afterwards. But if they refuse to mediate and go on to issue proceedings, for example, the fact that you've offered mediation is a useful strategic or a tactical weapon, because you may be aware that the courts have, in a number of instances over the last few years, penalised parties, even if they've been successful, for refusing, either unreasonably refusing to mediate or refusing to engage. So you write a letter saying, we'd like to mediate this dispute. They either unreasonably refuse, in which case you've got that sanction available, or they just don't respond at all. They just don't engage with mediation. And even in those circumstances, there have been instances of the courts penalising people in costs, that's to say, when they've been successful, either reducing the costs that they get ultimately, or not awarding them the costs at all. So there are ways of dealing with non-engagement or disengagement, and an offer to mediate early on is a good way to draw things out. As I say, hopefully they will agree and there'll be a mediation. But if they don't, then that puts you into a reasonable position should, unfortunately, proceedings ensue. So always worth bearing that in mind, in dealing with that situation where you've got somebody who just won't engage.
Yeah, no, I think it's probably helpful that the courts have changed support their view on mediation being a positive way forward. And if the other side decide not to engage, then that's beneficial really to trying to bring these things to a conclusion before litigation.
Sure. Yeah, well, the object, all of it, is to encourage people to resolve disputes before going to court. And I mean, that's always desirable. It's particularly desirable at the moment. I mean, the High Court has managed to operate reasonably effectively and efficiently during the lockdown, but many county courts have not, and they've got a huge backlog of cases that have built up over the last couple of months, with varying degrees of success in getting them going again. I mean, they're saying that they're opening them all up, but they're still, Central London County Court, as we all know, notoriously bad at the best of times, but frankly overwhelmed over the last couple of months. So if you can sort things out without going near them, so much the better.
Yeah, super. So I think this is probably moving on to our last scenario.
Yeah.
So this one was a bit of a bizarre experience, really. So I was working on behalf of a hotelier client who were looking to purchase a hotel abroad. I won't say which country, but basically I was instructed to proceed on the basis that this was a development, and as I was there, it would be pretty much in the final stages of completion, ready to occupy straight away and function as a working hotel. But when I arrived there, there was only about 50% of the works complete, and there really wasn't anything to inspect. Ask obviously all the relevant questions to the contractor about the program and funding, and then I hit an absolute roadblock because they weren't happy to divulge where the money was coming from, and who was a liquid or who had a financially viable contracting and subcontracting arrangement. So obviously I relayed this to my client, but they wanted me to report on it anyway. So giving my TDD, technical due diligence services, how was I able to issue a full report? How was I issue a report with an advice to my full capacity? That led to a sort of minor dispute between myself, the vendor, and the client. So we couldn't really reach a happy medium on what my report should say, because obviously they have to apply for funding as well. And then the vendor was panicking that their deal might fall through.
Mm. Well, I mean, what this raises, of course, is the issue of communications over long distances, overseas, and brings us perhaps back to what I was saying earlier about dealing with things online. Where people are a long distance away, obviously it makes it much harder, but nevertheless, it's still possible to try and have a mediation where everybody can play their part. And we can do that using the technology that we've got. And it's been demonstrated, as I say, over the last 3 months, how successful it can be. So it's obviously a difficult situation. It's going to be, it would be harder to resolve. But what mediation, online mediation, does certainly is gives you the opportunity to try and do so. And it's obviously in everybody's interest to do so. And again, no doubt there are all sorts of underlying issues. And with an international context, that could be more wide-ranging and more complicated. But the beauty of mediation, again, involving a neutral third party, is that there's somebody there for everybody to talk to privately, confidentially in the first instance. And just that process of talking, as I say, it's surprising how much can be achieved once people feel more comfortable. There is talking in a safe environment. They can talk more openly, get things off their chest, and you can try and get to the bottom of what the issue is. I mean, there's obviously been delays on one side. There may be reasons for that. It might be financial, maybe some other reason that who knows. But that's all the sort of thing that can be explored. And once there's an understanding of that, then it might be possible to get the thing back on track. So, that's one of the things that certainly online communication can do for you, especially, when, as in the current climate, that you can't physically travel to meet and talk face to face. So you can continue the conversation at least, and with a mediator, all being well, you'll get some resolution.
Very good. Yeah. So, well, we're almost out of time, but I've got one quick question kind of on that topic, really.
Yeah, so, sure.
Obviously, mediation can be done internationally. The UK obviously has a very strong legal sector. Is the UK sort of the leading benchmark for mediation?
No, not at all. I mean, mediation really came this way across the Atlantic from the United States. So it's been strong in the United States for many years. But it's very much an international community, and there are mediators now all over the world in many countries, and there is, mediators. There's a European Code of Conduct for mediators, which I abide by, and many mediators do. But it goes much further than that. So there are meetings of international meetings of mediators, annual conferences, and it's very much an international community. and growing all the time, all over the world. If anybody listening has any questions, they're more than welcome to write them down and send them in, and we'd be very glad to deal with those or any other questions that that have come to mind during the course of the mediation. I just want to thank Ben for joining me and hopefully making this a thought-provoking discussion, and to thank you, those that are listening, for doing so. Thanks very much, and as I say, do make contact if you need any information. Thank you. Bye-bye.
Thank you, Simon. Bye.